So Lynn, we've talked a little bit about the directives for healthcare and for finances and post, and all these things are documents that come into play while you're still alive. Can you talk a little bit about what documents you need once you pass?
Right. So when you die, I said the state has a plan for you unless you have a different plan. Which you likely want a different plan than what the state's plan is. So what legal documents do you need? Everybody's heard about a will. Everybody knows what a will does. It passes your assets when you're gone to whomever you want to receive them. Another dispositive type of legal document is called a revocable living trust. It does the same thing. It says, hey, when I'm gone, where does everything go? Each document has its own benefits and its own downside. Which is right for you really depends on what your particular circumstances are. Let me talk about a revocable living trust first. Let's say that you are single, you have property here in Washington and Idaho and maybe elsewhere in another state. You might want to have a revocable living trust. What do you have to do? You have to put the title of all your properties and all your bank accounts have to be retitled into the trust. And you are probably your own trustee, then you appoint a successor trustee. And when you die, the revocable living trust is supposed to operate such that the next people to inherit from you, and they do so without any help. By that, I mean, you don't even need to talk to a lawyer. You don't need to go to court. You don't need a probate. That's why everybody likes revocable living trusts so much. The problem with revocable living trusts is since they never go get any assistance, guidance from a lawyer or anybody because people don't want to pay for it, they get messed up all the time and it doesn't work like it's supposed to. And because of that, then the lawyer has to get involved at some point and the legal fees are much more than if people had simply received guidance. But theoretically, a revocable living trust can work well. Why people prefer revocable living trust to wills is that a will often will require that there be a probate. And all of us have heard, oh, probate, avoid it at all costs. If you hear about a probate, why did you hear about it? Because it was a probate gone bad, or an estate plan that was bad. So probate has a really bad name. What I encourage people to do is if somebody says, well, you need to probate your estate, ask the question, well, why is that? What benefit is that? We often set up people's estate plans with a will, but with no intent to probate. You have the will as kind of the safety net, but we can set up somebody's estate plan that their house pays on death to their son, their bank account to their daughter, their 401k divided between the two of them. There's all sorts of ways that we can avoid probate without a revocable living trust. And it accomplishes the client's goals without the need for probate because it really is set up to be automatic. Think about your life insurance policies or your IRAs or 401k. They have on them something called the beneficiary designation. If they don't, they should. And it says, where does it go when you're gone? You actually can do that with your house. It's called a transfer on death deed. You have to do the deed while you are alive, but if you do it correctly, usually you'll want to see a lawyer, then on your death, your house automatically goes wherever you said you wanted it to go. So that might be a really good option for people, much better than the state's plan. I do want to talk about, though, why probate might be a really good idea. And that has to do with protecting assets against long-term care costs and allowing the surviving spouse to qualify for Medicaid. Wills in our state, in Washington state, if you have a will that contains a special kind of trust, an asset protection trust, on your death, let's say husband and wife, husband dies, let's say it's $1 million estate, husband dies, his share of the estate or half, $500,000, through his will go into a trust supplemental needs asset protection trust for a surviving spouse. That requires a probate, and the probate will cost money and will take time, but a good estate plan doesn't have a lot of costs associated with the probate. It's a pretty simple process, though it's all statutorily mandated how it works. But why am I talking about having a probate? Well, you've got $1 million estate, husband dies, his $500,000 goes into a trust for his surviving spouse, wife. She has Alzheimer's. She needs to be in a care facility. She has in her own name, her own half of her estate, $500,000 that she will need to spend down, yes, for Medicaid, absent other planning. And that will cover private pay at the memory care facility and this and that. But after her money is down, she applies for Medicaid, not her, remember she has Alzheimer's, her attorney, in fact, under her durable power of attorney, applies for Medicaid for her. She has not just her own bank account with $2,000, she's got $500,000 in trusts that benefits her, and she qualifies for Medicaid. If you know anything about Medicaid's rules, a single person can only have $2,000 in other non-countable assets. But money in a trust, shouldn't that count? Shouldn't $500,000 count against her? It does not. So a will with an asset protection trust allows a couple to ensure that the survivor of them will never become impoverished, because the survivor will always have that nest egg, the decedent's share of their joint estate. She qualifies for Medicaid with $500,000 in a trust. And why that's so important? Yeah, Medicaid is paying for her long-term care costs, but that extra money is used to make her life that much better. Does she need somebody? Does she need a care manager? Does she need somebody to, sit with her? There's so many things that can be done with that money to ensure that her quality of life will be the best. This is something, this will with a Medicaid asset protection trust in it, and the benefit of a probate is something that most people don't understand. And that's why I want to share that with you, because by taking those steps while you're both alive, your outcome is going to be so much better.
So I think, Lynn, the takeaway, just what you were saying of so many of us don't understand it, because you're talking about legal documents, legal strategies, and we haven't been trained in all that, and so we don't understand it. But I think the takeaway is you have been trained in this, you do understand it. It takes an estate planning and or elder law attorney to be able to talk about this and create these strategies. And not all attorneys are created equal, just like not all physicians are created equal, or not all anybody's created equal. So finding a trusted, a competent attorney to guide you through the process is a really important piece. And as we were talking with Jennifer, what came about with the village plan as well is that each person has is unique. And their family dynamics are unique. And so tailoring the needs of the family is what these specialists do. It's what Village Plan does. They create a plan for the family's needs, in the same way that an estate planning and elder law attorney would create a plan based on this person and his family's needs and everything. So it's not a cookie cutter thing. I know a lot of people will download documents from the internet, and you can do that, certainly download these documents for the internet for free or for a modest price. But that does not address all of these nuances and all of these strategies, legal strategies, that your family might be able to take advantage of or want to know about. And that's why taking the time and spending the money to consult with a qualified estate planning and elder law attorney is so critical right now while you're still at full capacity and you can make these decisions. Is that a fair takeaway?
Yeah, I would agree. Even an estate planning lawyer, what you have to, this is the question. If you're looking for an attorney and you have concerns about long-term care costs, and you have a concern that there's going to be enough money there to pay for you or your spouse, seek out not just an estate planning lawyer, but an elder law attorney and one who is knowledgeable about Medicaid's rules and the benefits. And because that is a subcategory niche within even elder law, which is within estate planning. So just like you wouldn't go to a general practitioner for your rotator cuff surgery, you really want to find somebody who has done what the area where you have a concern. If you have a concern about long-term care costs, seek out someone who is knowledgeable about what the state benefits are.